Thank you to everyone who's joining us today. Thanks for taking time out of your day to talk to Julie and I a little bit about trust, one of our favorite topics. And today we are going to be doing a complete trust takeover, as Kyle said. Over this next hour, we're going to be covering anything and everything you might have possibly wanted to know about trust. And specifically, some of the things that we're going to be talking about during our seminar. We're going to talk a little bit about how assets are managed after they're transferred into a trust. We're going to walk through some common scenarios or examples where we might use a trust or recommend a trust for you and for your estate plan. We're going to talk about how we can customize the trust to really craft a trust that works really well for you with your wishes and desires, how we can implement the decisions that you want, and we can get involved, the people you want to get involved, and assign those people the best role. We're going to cover who holds the key to unlocking the back door of the trust and pulling property out if we need to later on. And we're also going to talk a little bit today about how we could use a trust to fund long-term care costs or protect the trust assets from the cost of long-term care. And really, whenever Julie and I were thinking about this seminar today and designing it, we really wanted to design this seminar for anyone who really just wants an introduction about trust. Maybe you've always wondered, well, what exactly is a trust? How does it work? Who's involved in the trust? Maybe I've heard about a revocable trust versus an irrevocable trust, but I don't really know the difference or when I would want one versus the other. We're going to cover all the basics here today for you. This seminar is also for those of you who might be scared or a little worried that someday you might not be able to make decisions for yourself anymore for one reason or another. And you want to make sure that you are doing everything you can in your power to plan ahead of time to make sure that you and your family are in control of your assets and your future. But before we dive into all of that, we wanted just to take a moment to introduce ourselves a little bit more. And so I'll pass it over to Julie.
Fantastic. Yeah, just so everybody knows, because I had a client yesterday that really thought a revocable or an irrevocable or revocable trust was going to protect against the cost of long-term care. While everybody's still listening, we have your attention. That does not work. We have to use some part of a trust that is irrevocable or revocable. I'm going to talk about that later on, but I just bring it up right now because it still seems to be out there that we can have a revocable trust that works for that. So that's part of today. It's part of us trying to share some information with you to help you become educated so you can make the best decision for your life. As the slide talks about, I actually started Steinbacher, Goodall, and Yurchak 20 years ago out of the garage of my house. And now it is, again, 4 locations. And really the secret to the success, it really is twofold. One, we really have always just focused upon elder law and estate planning. And you see the list there, and that's really grown to, we have a focus on dementia, Alzheimer's planning. We have a focus on elder care navigation, trying to help people navigate the healthcare industry and what type of care they need. And so it's grown, but it kind of comes out of just simply what happens if you die? What happens if you get sick? And what do you need to do to plan today for those things to happen? On the next slide, it shows you some books that we have available at our office. These are books that either I wrote a chapter of or somebody at our office did, or we wrote the entire book. And we have these available for anybody who wants them. And so you can simply type into the chat, email Kyle, or call our office, and we're happy to provide that. We think it's really important that people understand and feel comfortable with what they've done. The book that is not on there, which is applicable to today really, is I am one of the authors of the Pennsylvania Trust Guide. And that's the guide that attorneys across the state of Pennsylvania use to advise about trust law. And that's really important in this situation. At our office, we draft our own trusts. And so if you want something in your trust, Megan and I sit down and we actually draft the language. She may draft it, I may review it. But the thing is that we can really deal with your unique situation to make sure your goals are met. And on the next page, talks about the ACTEC, which may not be anything that anybody knows very much about, but I would say that I'm one of the only attorneys, if not the only attorney in our local area to be an ACTEC fellow. And this is you're chosen by your peers nationally in this type of law. I also went on and got my LLM in estate and elder law. That's because I'm curious and I love to learn. So I continued on. But you'll see up there, we have a wide variety from a TED Talk to helping veterans who desperately need our help. So what we try to do is help anybody who's kind of in that second half of life with the issues that they're confronting for their estate planning. And I'll hand it back over to you, Megan.
Okay, thank you, Julie. So again, my name is Megan Ingram. I'm another attorney here at Steinbacher, Goodall, and Yurchak. I primarily work in our firm's wealth protection planning department, working with Julie with clients who have estates of around 2 million or more. We're really looking at some tax planning considerations at that time, but I also do quite a bit of long-term care planning and special needs planning as well. So I was actually fortunate to be named as a rising star by Super Lawyers for 2022 and 2023. And I've also gone through some additional training to be a certified dementia practitioner. So I've gone through some additional steps so I can best help our clients and their families who might have a dementia diagnosis or they're heading in that direction, so we can best help them navigate that whole process and that whole journey. I graduated from Penn State Law in 2020, summa cum laude, and I did my concentration in taxation. So just in case law school and all the reading that goes with that wasn't fun enough, I really like to dig into the tax code just to make it even more fun. But really, now that you know us a little bit better, we will get started without further ado on everything you need to know about trust. So we wanted to start off today really at level one. What exactly is a trust? We often see that this is the first question that clients ask us. So really what a trust is, it's a separate legal entity. It's separate from yourself and it's able to own property or assets. And what the trust document is that Julie and I are drafting and we have you sign, that's really just the written set of rules that say what you can and cannot do with the property or the assets that the trust owns. In a nutshell, that's a trust. And in that trust document that we're going to be drafting, there are a couple key things that we're going to want to make sure are in there. First up, who are the beneficiaries of the trust? Who gets to use and enjoy the trust property while it's in the trust? We're also going to want to name the trustee. Do we need a trust protector involved? What are the powers and the responsibilities of each of those people? We're going to want to make sure we include any kind of tax clauses and we address how the trust assets are going to be taxed. And we're going to want to provide as much creditor protection as we can in the trust. We're going to do that through a paragraph there called the spendthrift clause. We are going to dive into each of these things in detail throughout the whole seminar today, but this is just a really general introduction to some of the things we're going to be thinking about with our trust. So as I sort of already mentioned, the next general category of trust is a revocable trust or an irrevocable trust. With a revocable trust, as you can guess, probably by the name, a revocable trust can be revoked or changed at any point in the future. You really have broad discretion to change this trust in the future if you want to. With a revocable trust, you also have direct access to any of the money, funds, property, whatever you put in the trust. If you want to pull that out later and spend it, you really have a broad power to do that. But as Julie already mentioned a little bit ago, because you have direct access to the money and the things in the trust with a revocable trust, it really doesn't offer a whole lot of creditor protection to you because you have access to the trust assets, so do your creditors. That includes the nursing home. On the other hand, with an irrevocable trust, you guessed it, it cannot be freely revoked or freely changed however you want in the future. But I always like to note that whenever we're talking about revocable and irrevocable trust, it's not as much of like an either or scenario, like a light switch, where either the trust is revocable or it's irrevocable. We like to think of it more in terms of a continuum or a spectrum. How revocable is it? What am I able to change about the trust? Or what hoops do I need to jump through in order to make a change to this trust? That's really what we're talking about. If it's going to be harder for you to make changes to the trust or to get rid of it later, that's most likely an irrevocable trust. Also, with an irrevocable trust, you are not going to have direct access to the money or the property that's in the trust. So once you put something in the trust, you don't have the free power to reach into that trust and pull it out and spend it however you want. But because you can't access the money or the assets in the trust, neither can the nursing home. That's the kind of trust, that irrevocable trust, is really what we're going to be using if we're looking at creditor protection or long-term care protection for you. So after we cover the basis of what a trust is, another question that we commonly get from folks is, well, do I really need a trust? Is a trust really for me? Do I have enough money to justify having a trust? I think, we've probably all in here have heard about the trust fund babies, or the children of the ultra wealthy families that have a trust fund set up for them. And it kind of seems like it's, an unlimited pool of wealth that they can pull from. And so sometimes people associate a trust with people who have millions, even billions of dollars. That's not necessarily the case. There are a lot of different kinds of trusts out there. So there are a lot of different reasons why we might use a trust or recommend a trust for your estate plan. We've included just a couple of them here. The list is really much longer of reasons why we might recommend a trust. But one of the reasons why we might recommend a trust for you is because we want to avoid probate. If we transfer property into the trust during your lifetime, then whatever property or assets is in the trust does not have to go through probate. That could be really beneficial. We also might recommend a trust if you want to have some kind of management or power to control the assets after you pass away. For example, maybe you want your beneficiaries to receive their inheritance as payments spread out over a period of time instead of just getting one lump sum whenever you pass away. In order to do that, we need a trust. We also sometimes use a trust if we're concerned about protecting your beneficiary's inheritance from some of their creditors. And we're going to look into some of those creditors in a little bit deeper here in a couple slides. We also commonly use a trust for tax planning purposes. But ultimately, the most common reason why we are incorporating a trust into an estate plan here in our office is because we're looking at long-term care and we're trying to protect assets from the cost of long-term care. And as I said, whenever we are looking at using a trust to set up asset protection to protect assets from someone's long-term care costs, that's whenever we're going to be using an irrevocable trust. We found that an irrevocable trust is most commonly the best way to protect assets because it allows us to transfer property or assets out of your name and into the trust. So it's a way that we're able to lower the number of assets in your name that's available to pay for your care, while still allowing you to have some level of control over the assets after they're in the trust, while also protecting them from your creditors and from any creditors that your beneficiaries might have. So again, anything that we put into an irrevocable trust, an asset protection trust, as we call them, during your lifetime, it's not subject to the cost of your nursing home care. Also, it's not subject to the estate recovery. What that estate recovery is, let's say if someone goes into a nursing home and if they are receiving Medicaid benefits to help pay for their long-term care costs, which is a really common planning strategy that we do here at Steinbacher, Goodall, and Yurchak, help our clients qualify for Medicaid and have Medicaid help pay for their long-term care. If someone is receiving Medicaid benefits during their lifetime, then after they pass away, Medicaid can try to reimburse itself from the cost it's spent on that person's long-term care during their life by recovering the assets in that person's estate after they pass away. However, if we use a trust and we put property into the trust during your life, it's no longer titled in your name. As I said, it avoids probate and it doesn't go through your estate when you pass away. So it's not subject to that estate recovery. It's not subject to that Medicaid recovery after someone passes away. And ultimately, finally, another great reason why we use an asset protection irrevocable trust for long-term care protection is because it's a way that we can protect the asset from your creditors, but also from your beneficiaries' creditors. Your beneficiaries' creditors, this is what we call the 4 Ds. And really what we're talking about here is the divorce, debt, disability, or death that a beneficiary might experience. We have quite a number of clients come in and say, for example, I want to protect my house from the nursing home. I want to protect my house from my long-term care costs. So I'm thinking of gifting my house to my kids for $1. I don't want the house in my name. I want to make sure my kids get it and the nursing home doesn't. Well, that's certainly a way, gifting assets to your kids. It's certainly a way to get something out of your name so it's not available for your care. But that opens up a whole other can of worms. That can of worms is the 4 Ds that we see right here. So just going through that scenario, if you were to transfer your house to your children, then first off, you no longer have control over your home anymore. It's not an asset that you own. It's an asset that your child owns. That also means that if your child were to get divorced in the future, your house is now an asset that they own. It could possibly be subject to their divorce proceedings. On the other hand, if your child has any debt, your house is now an asset they have. Their creditors could try to go after it. And please know, whenever we're talking about debt, we're not necessarily, only talking about if your child is doing well at managing money. What if your child were to be in a car accident in the future? And if for no fault of their own, but what if they get sued above and beyond what their insurance can cover? Suddenly they might have a creditor through that lawsuit. Your house or anything else you transfer to them could possibly be an available asset for that litigation settlement. Or sometimes really unfortunate situations we see where a child becomes disabled and they need care. Now suddenly the asset that you transfer to them is now available to pay for your child's care. Or heaven forbid, if your child would pass away before you did, your house is now an asset that they owned upon their death, and it would go according to their last will and testament. It would pass through their estate on to their beneficiaries. So really, we have found that an irrevocable asset protection trust is a far better strategy in almost every case to protecting assets from the cost of your care, but also from these risks, the 4 Ds that we see from your beneficiaries. Okay, so now that we've covered what a trust is, why would we want to use a trust? Now we're really going to dive into the mechanics of a trust and cover, first up, who's involved in the trust? Who are the players here who are going to be involved? The first person involved in trust is called the donor. This is the person who creates the trust and transfers property into the trust. This could be you. So for example, if you decided to put a trust in your estate plan, you would be the donor of the trust. The next person involved in the trust is the trustee. The trustee is the one who's responsible for managing the assets that the trust owns. And a really great thing is that the donor can also serve as the trustee. So if you set up a trustee, and I should say in almost every trust, a lot of the trusts that we use, the donor, the person who sets up the trust and puts money in the trust, can also be the trustee and still have the power to manage and control those assets while they're in the trust. So for example, some of the responsibilities that the trustee has with trust property is paying any expenses or paying for any kind of maintenance associated with the trust property. They have to set up the trust checking account or trust bank account that's going to hold the money that the trust owns to pay for those expenses. The trustee also has the discretion in deciding how the trust assets are going to be invested and managed. So, the trustee gets to decide if we put money into a trust, the trustee gets to decide, is that going to be held in an investment account, mutual fund, money market, savings account? Those are all decisions that the trustee gets to make. The trustee can also choose where those investments are going to be held, which bank or financial institution is going to manage and hold those investments. The trustee can also decide if they want to self-manage those investments, or if they want to hire a financial advisor, an accountant, some other professional to aid them with their roles and responsibilities. These are all decisions that the trustee can make. And you, as the donor, if you decide to be your own trustee, these are still decisions that you can make and control that you can still have over your property that you put into the trust. So the next person that might be involved in a trust is a trust protector. And really, a trust protector is going to be used when we're looking at an irrevocable trust, those asset protection trusts, when we're looking at long-term care planning. So as I mentioned, with an irrevocable trust, you don't have direct access to the money and the assets that are in the trust. If once you put money into that trust, you can't pull it out later. But we have crafted our trust to have a back door. So if money ever needs to come out of that trust later on in the future, we have put a person in place called the trust protector who holds the keys to the back door. And the trust protector's only role in the trust is to pull money out of the trust if it's needed. The trust protector is typically going to be two people, and it can't be you. It can't be the donor, because once again, we can't let you have access to the money in the trust. But the trust protectors, what they would be doing is pulling money out of the trust and distributing it to the beneficiaries named in the trust document. Once again, it can't be you. You can't be the beneficiary during your lifetime. But once that money is pulled out of the trust by the trust protector and given to the beneficiaries could then use that money to pay for things for you. So for example, the trust protector could pull money out, give it to the beneficiary, and the beneficiary could buy things for you, pay for bills and expenses on your behalf. This is really a way that you are still able to benefit from and enjoy the money that's in the trust without giving you direct access to it. Because once that money passes through your hands and touches your hands, unfortunately, we're really looking at a big loss of the creditor protection there. This is a way that we can still get the money out and get you to enjoy it without it touching your hands. A lot of times, whenever we explain this strategy to our clients, there's kind of some pause because you are really giving a lot of control and a lot of power over your trust to your trust protector and your beneficiary. You really have to trust the trust protector. Maybe there was a little bit of a pun intended there, but anyway. If you, though, see in the future that your trust protector or the beneficiaries aren't doing what you would want them to do, if you don't approve of the way that they are being involved in your trust, as I said, we craft these trusts so that you still have a lot of power over your trust. We built into this trust that you have the power to fire the trust protector and appoint someone else as the trust protector if you decide to in the future. Same thing, most often, not in every case, but in a lot of cases, we're able to set up a trust so that you have the power to remove a beneficiary later on if you were to decide. So if the trust protectors and the beneficiaries aren't following your wishes, you can make those changes in the future if you need to with our trust. So the next thing to think about with a trust is, when is it going to pay out? And again, we have a couple different options here. Option one, a trust could terminate whenever you pass away. And at that point in time, any money or assets that are left over in the trust are just going to be paid out to the beneficiaries at that time. Another option is maybe you don't want the trust to terminate when you pass away. If you want to still maintain some kind of control over the trust assets after you pass away, then the trust can continue on and continue to exist after you pass away and can continue to manage the money and the assets that the trust owns going forward, and how your beneficiaries can access that money. Okay, so after we have made all the decisions we need to about the trust, we have the document drafted and everything looks great, we're happy with it. Of course, the next question is, well, what are we going to put into it? What assets are we going to put into this trust? The donor, the person who sets up the trust, is the person who decides what goes into the trust. In order for a trust to own property, we actually have to transfer that property, that asset, into the trust. And what that looks like is we are actually changing the owner of that asset. So for example, if we are putting your home into a trust, we're going to have you sign a new deed that changes the owner of the house from you and transfers ownership to the trust. The trust is going to be the new owner of the house. Same thing if we're putting any kind of investment accounts or any kind of money into the trust, we're actually going to do a change of ownership of that investment account to take your name off of the title of that account and make the trust the title owner of that account. That's how we put property into the trust. A lot of really common things that we put into a trust, I think the most common thing we do is real estate. A lot of people want to protect their house or any kind of investment properties that they have from the cost of long-term care. Or, we're looking at avoiding probate for real estate. Real estate's really most commonly what we put into a trust, but we can put a lot of other things in the trust as well. For example, any kind of non-qualified annuities or investment accounts we can put into a trust. Bank accounts, life insurance policies are another really popular thing that we put into a trust. If you have a life insurance policy that has a cash value to it, we often look at protecting that cash value from the cost of your long-term care by putting that life insurance policy into your trust. Or, maybe we might talk about putting some bonds into your trust. Unfortunately, there are a couple things that we just cannot put into a trust. The number one thing here is retirement accounts. We cannot put a retirement account into a trust during your lifetime. That's because, as I said, in order to put property or an account into a trust, we have to change the owner of that account. And oftentimes, whenever we are looking at putting the retirement account into a trust and doing that ownership change, it would trigger a lot of tax implications that we most often want to avoid. So a retirement account is typically not something that we would put into a trust during your lifetime. And the other thing that we can't put into a trust during your lifetime is a vehicle. In Pennsylvania, we're just not able to put vehicles into a trust. So again, as we're looking through the list of your assets and everything you own, and we're sort of walking through these decisions of what we're going to put into a trust. Again, the things that we're going to be thinking through, first off, what do we want to protect from the cost of your long-term care? What do we want to protect from the estate recovery if you end up receiving Medicaid benefits to help pay for long-term care? What do we want to protect for your beneficiaries? And specifically, what do we want to protect for them and also protect from their own divorce, disability, or death while the property's in the trust? However, like we've said, with an irrevocable trust and an asset protection trust, those kinds of trusts where you don't have direct access to the money that you put in the trust. Another thing that we're going to really be thinking about here when we're contemplating what we want to put into the trust is that fact that you're not going to have access to it if the trust is an irrevocable trust. So while we really want to protect as much as we can, and we want to put you in the best place as you possibly can be if you would ever need long-term care, we also don't want to tie up so much of your assets and so much money during your lifetime that it really impacts your standard of living, and you'd have to go through your trust protectors anytime you needed to get money for anything. So that's really kind of the trade-off and the pros and cons that we're going to be thinking about when we decide what we're going to be putting into a trust. Okay, so after we put everything into the trust, the next thing to think about when we're deciding how we're going to set up a trust is how it's going to be taxed. Whenever we're thinking about taxation of trust, there's kind of two broad categories of trusts. The first kind of trust is a grantor trust, and the other kind of a trust is a non-grantor trust. Most often, we're going to be using a grantor trust. That's the most common kind of trust that we're using here. With a grantor trust, we are able to use your social security number as the donor, your social security number as the tax ID number for the trust. So that means any kind of income or interest that is earned on the assets that are in the trust, that's going to be reported on your personal tax return, and it's going to be taxed at your personal income tax rate. That's typically much more favorable than the trust tax rate, which are usually going to be higher than the tax rates you're paying as an individual. Also, by using a grantor trust, we're able to preserve, for example, if you put your primary residence into a house, we're able to still preserve all of those benefits if you would decide to sell your primary residence. For example, that exclusion of capital gains for a primary residence, we still get to keep all of those tax benefits for you with a grantor trust. However, even though, despite all those positive things, because with a grantor trust, during your lifetime, the property in the trust is taxed as if you still own it, then that means that whenever you pass away, Pennsylvania is still going to tax it as if you still own it. And that means whenever you pass away, your beneficiaries are still going to pay inheritance tax on the inheritance they receive from a trust after you pass away. That's not always a bad thing, though, because if someone pays Pennsylvania inheritance tax then as the laws currently stand right now, they are going to get a step up in basis for capital gains tax. So any amount of appreciation or accrual in value that asset had while you were alive, while it was in the trust, that level of appreciation is going to get wiped out, and they're not going to have to pay capital gains on that amount of appreciation if they decide to sell it later. So, oftentimes the inheritance tax rate that someone would pay is usually going to be lower than the capital gains tax rate. So, looking at, the lesser of two evils here, it's typically, not always, but usually better for a child to pay the inheritance tax and get that step up in basis later. So, Julie, I saw you unmuted yourself. Did you have anything to add there with your grantor trust?
Nope, I was just getting ready to take over when you were done.
Sounds good. I'm almost done. Just have a couple more slides about tax.
No rush.
Hopefully they'll go pretty quickly, because I know not everyone loves taxes as much as we do. So, so other than a grantor trust, the other kind of a trust is a non-grantor trust. With this kind of a trust, we're not using your social security number. We're going to have to get a separate tax identification number just for the trust. And the trust is going to have to file its own separate tax return. And everything, all the income and interest is going to be taxed at that trust tax rate. However, because one of the benefits of the non-grantor trust is that the beneficiaries are not going to have to pay Pennsylvania inheritance tax as long as you live for another year after you put the money into the trust. But again, because your beneficiaries aren't paying inheritance tax, they're not going to get that step up for capital gains tax purposes. Whenever we're talking about taxes, this is just kind of a breakdown of specifically the percentages that we're talking about, the rates that we're talking about here. For Pennsylvania inheritance tax, there's a 0% rate between spouses. Any children, grandchildren, lineal descendants, they're going to pay a 4.5% inheritance tax rate. Siblings are taxed at 12%, and everyone else is taxed at 15% in Pennsylvania. There are a couple of exceptions, though. A couple of things do pass inheritance tax free. I think the biggest thing is life insurance policies. So if you have a life insurance policy, whenever you pass away, whoever is named as the beneficiary is going to get that payout without having to pay inheritance tax, which is fantastic. Another tax, Pennsylvania tax, that we're going to be thinking about when we're doing trust planning is whether we're going to have to pay any kind of realty transfer tax if we're putting real estate into the trust. If realty transfer tax does apply, that rate is 2% on either the fair market value of that piece of real estate or the sales price, whichever is greater. But again, there are some exemptions here. For example, transferring real estate between spouses or transferring real estate between a parent and a child, that's exempt from realty transfer tax. And so there are often times whenever the transfer of real estate to a trust is also going to be exempt if the beneficiaries of the trust ultimately would be exempt themselves. Looking at federal tax rates here, a person currently has over $12.9 million federal tax exclusion. So a person can give away over $12.9 million during their lifetime and after they pass away combined before they have to be concerned about federal and transfer tax, federal estate tax. And that is per person. So for example, a married couple, each spouse gets over 12.9 million to give away. And once one spouse passes away, if they don't use all of that, their spouse can port over their unused exemption. So a married couple effectively gets about 25 million to give away. That number is set to come down in 2025, if not sooner. Whenever that exemption sunsets in 2025, it's going to come down to around 6 to 7 million per person, adjusted for inflation. So we are still looking at if anyone has an estate around this 12.9 million or a $25 million estate for a married couple, or if we think, their estate might be much lower, but after this exemption comes down, they might be looking at a federal inheritance tax. We are really kind of examining that and keeping our eye on that when we're doing planning for folks who are in those ranges. And finally, we already really talked about income taxes for trust. We're going to be thinking about how the trust assets, the income is taxed at the federal level and on the state level based on whether the trust is a grantor trust or a non-grantor trust.
I did get a couple direct message
Okay.
questions. So did you say then life insurance policy proceeds have no inheritance tax, whether in the trust or not?
That's correct. Yep. A life insurance passes inheritance tax free in Pennsylvania.
Okay. Is there any advantage in having investment accounts in a revocable trust?
Yes, there could be advantages. I think the top one is that we are able to avoid probate with those investment accounts. So that's usually kind of what we're thinking of. We want to avoid the probate process after someone passes away for that investment account. That's really something, though. There are a lot of different kinds of investment accounts that often have a lot of different bells and whistles. So it's usually something that whenever Julie and I are meeting with someone, we're really taking a look at that specific investment account to figure out the best kind of trust for that account and the best planning strategy for that particular kind of investment.
Okay. How about the $2 million boundary? What is the $2 million boundary? Is that a thing? No?
That could have been you discussing wealth protection planning at our office. That's kind of a soft boundary, if you will.
Yeah. So in our office, whenever someone calls in for estate planning, we typically kind of, as Julie said, a soft boundary is whether someone's estate is under 2 million or over 2 million. And that sort of determines whether someone is going to be, focusing more on tax planning. And maybe we're not quite as concerned about paying for the cost of care if someone's estate is over 2 million. Versus if someone's under 2 million, we're going to be looking a lot more closely at paying for long-term care if needed. So as Julie said, that's a really soft boundary. That's just sort of a starting point for our office in determining what our goals and what our focus is going to be when we're crafting an estate plan.
Is there any advantage in having investment accounts in a revocable trust?
Yeah, so I think we touched on that. We get to avoid probate. Julie, do you have anything to add to that?
Well, I think you're correct. You get to avoid probate, which allows it to pass to your beneficiaries in a simpler manner. But the other reason that that's really important is we find out that as people age, sometimes they can't continue to make their own decisions. And it's actually easier for your children to take over as an alternate trustee than to use the power of attorney. Now, legally, they should have the same effect. So legally, if I appoint somebody my power of attorney financially, that person should be able to go to the bank and deal with my assets. We just have a lot of problems with those powers of attorneys being accepted later on. It's much easier if you had all of your assets in a revocable living trust or an irrevocable trust. And instead that we're just now having an alternate trustee, a successor trustee take over. So I think that that's, really important. The other thing that we often use trusts for is when your children receive it upon your death, receiving it within the trust gives them some creditor protection. So Megan talked about the fact that it doesn't do much for you, but it does do for your kids. So if we're worried about divorcing spouses, for instance, or other creditors, we often will use a revocable trust for investment accounts for that purpose. Great.
And I did have another question here. If the trust donor had a will before creating a trust, should there be changes made to the original will?
Typically, yes. Not always, but typically, yes. So what's going to happen is anything that is controlled by that trust the will is not going to be able to control it. So we don't want documents that say different things or seem inconsistent. The other thing is that as long as we have a trust, we want to be using it. And so often, instead of it paying outright to children, even if we didn't put the items that we own, the assets that we own in the trust during life, we're going to want them to pay out to that. And so we'd have to update our will to have that happen.
Can I sell my home if it's in a trust?
Sure, do it all the time. So that's probably the number one, like if I met with somebody 10 years ago and they set up a trust, that's probably the one time that they will come back, and that we'll help them through that process. They don't need us to help them, but I see that happening a lot. People downsizing or deciding to move to a community, just, I don't know, we're getting maybe 6 inches of snow some places in the area tomorrow. And maybe after shoveling the snow, you'll decide you want to downsize and don't want to do that anymore. But absolutely. So even whether it's a revocable trust or an irrevocable trust that we use for nursing home care, where you remain the trustee, you are able to sell your house without talking to anybody else, without getting anybody else's signature. And it's no different, really, than you selling it when it was in your own name.
What does it cost to set up a trust for assets less than $1 million?
Well, I have the best attorney answer for that, and that is it depends. I will give you some ranges though, because so it really does depend. It's not about the assets that you have, it's about the complexity of your situation. And what goals we're trying to do. So that is why at the end of this, we're going to talk about the fact that we offer a free initial consultation for people who come on these webinars and kind of get educated a little bit. And in that free initial consultation, we would talk to people about their specific situation and quote them a flat fee. But what I can tell you is that when we think about powers of attorneys and wills, those things are less expensive. So a power of attorney, might be $200 or $300. When we get into trust, we are getting into more expensive investments for us. And part of that is we want a trust that's going to work with us. We have to draft the trust, and then we have to fund the trust and make sure all your assets, like your life insurance and your deed to your house, all got into that. So we work together for about 6 months. So it would not be unusual that if we were doing trust work, that we would quote you a fee that was in the thousands of dollars. And that's, it would, where that lands really depends. Do you have children who have special needs? Are we just worried about protecting a farm? Are we worried about protecting multiple assets? Are we going to use one trust or 2 trusts or 3 trusts? And so, again, trying to be as helpful as I can to you, but not being able to say to you exactly what it would cost. I can tell you, I've been in situations where people who have more money, I actually quoted less because it was less complicated. So it's not necessarily a money issue.
So,
all right, are we good?
But the questions keep coming here.
Okay.
No,
that's all right.
Okay.
This is their time.
Yep. Have you ever crossed the bridge of cashing out a large IRA greater than 500,000 to plan for nursing home protection?
Yes. Yes, we have.
Mm-hmm.
So if you can cash out an IRA, so we look at your individual situation, but I have been in situations where that made sense. It made sense for people to cash out, pay the tax, and then fund a trust. Particularly makes it, and to do that all in 1 year. It particularly makes sense to do that if you have a diagnosis, like a new dementia or Alzheimer's diagnosis. I've also had people who do that over a series of years to reduce, the taxation. So maybe we just did one where we were doing part of the IRA in 2022, and we're going to do the rest of the IRA in 2023, just to minimize the taxes a little bit. And so, yeah, we definitely do that type of planning. And we have people who often just want to make sure that whatever it was that they, the protection, the 5-year rule, they just want to get it started. Right. And so we absolutely can do that. We like to do that in consultation with your accountant, so we can figure out how this is going to affect you from an income tax standpoint, kind of specifically, not just, here's your usual rate. We also have to know that that can cause your Medicare Part B premium to increase for a year. Sometimes we will still do that. So we like to make sure people understand the ramifications, but I would say it makes sense for some people and we do it.
And then just to clarify, retirement accounts, they cannot be placed into irrevocable, but can be in revocable, correct?
Yes. So a retirement account, whether it's an IRA, 401k, those types of things, they can be placed into any type of trust. But the reason that we don't is that it's a taxable event. So that other question about the $500,000 IRA, if I was going to put that into a trust, I'd have to cash it out first, pay all the tax on it, and put the remainder in. Now, if you had a Roth IRA, that can be different. We are able to do that. But that's why when Megan said we don't do that, that's why we don't, because you can't do it without a taxable event. Now that's different than when people pass away. If somebody passes away, it can go into a trust as an inheritance.
And you could avoid probate by
Yeah.
trust.
Yeah.
And if you sell a house that is in a trust, are you required to put the proceeds from the sale into the trust?
Yes.
Kind of depends on what the trust says.
Yeah. It does depend on what the trust says. But in most situations where you've set up a trust that protects the cost from the cost of long-term care to be able to access Medicaid, you're going to want to put the proceeds back into the trust. And the reason is because that keeps that protection if I pull them out. Now, in reality, what happens is many times people might be downsizing, selling one house, the proceeds go back into the trust, but then they use those proceeds to buy another house in another location, or maybe it's a townhouse with, less care and maintenance, those types of things. We also have situations where people will sell their house and want to either gift some money out to kids or hold on to some money themselves. One time I've had a man who wanted to buy himself a truck. You are able to do that. You just have to, like Megan said, depending on what the trust says, we'd have to follow the formalities of the trust. So let's say in that situation, your kids were the trust protectors. So like in my situation, I have 3 kids that say that they were my trust protectors. They would have to sign saying, yes, they agreed with this. One of those kids would get in, pull it out to themselves, and then give it back to me to buy the truck. So we do that often. Well, I shouldn't say often. We sell houses often. It is not often that people actually want to pull money out of their trust, because usually when we do this planning, people have money inside the trust and they have money outside the trust. And even though they're able to pull money out of the trust, if they sit down and talk to me about it, they realize it makes more sense not to pull that money out, but rather use the money that's outside the trust for whatever it is that they want.
Do you advise on pros and cons of which state to establish the trust in? For example, Pennsylvania versus Florida versus South Dakota.
We do advise on that, although I would tell you the majority of trusts that we do end up being Pennsylvania trusts. So South Dakota being in there means to me that person's looking for some creditor protection. And there are some advantages to a few different states that give better creditor protection. When I've been in that situation, I've actually usually used a Delaware trust rather than a South Dakota trust because I like the Delaware law a little better. So that's why. As far as Florida, usually our advice there, a lot of times we're establishing trust in Pennsylvania, putting real estate in it. That makes it a Pennsylvania trust. Now, if we just have assets, we could do a Florida trust, and our office actually could do that because we have a Florida attorney, Jenna Franks. But usually that does not happen because there's nothing advantageous of Florida law over Pennsylvania law. And if you're already a Pennsylvania resident, we should just use a Pennsylvania trust. So in my career, I have done those in different states, and I can talk to people about that. But you would have to really want some creditor protection that was unusual. And then you could use South Dakota or an LLC in a different state. But again, I would tend to like the Delaware law better than the South Dakota law. Also, we're closer to Delaware, so it's easier to get physical presence there. And sometimes you really do need some physical presence to establish it. Megan, do you have anything to add to that?
No, I think you touched on everything, Julie. As you said, it just because the trust sometimes says it's in a certain state, sometimes there needs to be a little bit more to it, like you said, physical presence. So sometimes those are all factors that we look at when we're looking at different trusts.
Yeah.
Does a trust need to be in force for a number of years before a nursing home cannot take your assets? What takes precedence, a will or a trust?
Yeah, so two different questions there. The first one, how long does it need to be in existence? 5 years is the best. And I'm going to talk about that a little bit. What takes precedence? Well, again, it depends because they may control different things. So if something's in a trust, like if I move the deed from your house to the trust takes precedence because it controls anything that's within that trust. So what's going to happen is one doesn't rule over the other. I'm going to look at what's part of your probate estate, and that's what the will controls. And that would be anything that was just in your name, did not have a beneficiary. And I'm going to look at what the trust controls, and that's going to be anything that the trust is the beneficiary or the trust owned during life.
Should the questions keep coming? Should the beneficiary of the donor's IRA or Roth IRA be the trust and not the children directly?
Yeah, so a lot of times I do like the Roth going to the trust. And so a lot of times at our office, this is a little bit more of a complex thing, but if we have husband and wife, the first beneficiaries we'll make are that trust. Now it's a particular type of trust. So if you already have a trust, you shouldn't go do this without talking to the attorney that did the trust or the financial advisor. They may have an understanding, but certain types of trusts, I want to make the trust the beneficiary. And then the secondary beneficiary, I want to make the spouse. Mm-hmm. And then the third might be the children. And why would I want to do that? Well, we already said we can't take the IRA and put it into a trust without paying a huge tax. So let's take my situation. So my husband's name is Donald. He has an IRA. If he were to pass away, it would go to me through the trust. And I would want to do that if I was sick, if I thought I was going to need care, or when he dies, I get to choose and say, no, I'm not sick and I need this money to live off of. And so I'm going to have the trust disclaim, which I have the power to do. And then it's going to come down to me. And so we set that up all the time for people. And what happens is we really decide when somebody passes away, where it goes. So just so you guys know, when I first became an attorney, that was always kind of the problem. We didn't have as much flexibility back then. And so it was just like, if you can tell me when you're going to die and what of, I can make a great estate plan, what the law is going to be. But as the law changed, we kept having to change it. Today, we really try to set up a plan that does not need to be changed, even if you get sick or the law changes. We try to set up a plan that has choices to spouses upon the first spouse's death. And now that doesn't work in every family situation, but in many family situations it does.
What section of our revocable trust would we find what all we have in our trust? Like, for example, house, investments.
Yeah. So if you got your trust at our office, it's not going to be a part of any section of the trust. Rather, it's going to be on what we call the asset list. So if you wanted to know, you would call our office and ask for a copy of the asset list. Some law offices will do just a simple schedule at the end that just lists the asset. So there could be a schedule in the back that would also show you that. But I have to tell you, sometimes those schedules are misleading, because just simply putting it on a schedule does not put it in the trust. So if you have a trust and on the schedule, it says your Edward Jones account, for instance, is in the trust. But when you get your Edward Jones statement, it says you still own it. It's not in the trust. Pennsylvania law does not allow that to happen. You actually have to change the ownership. So you would have remembered going through a situation where you opening a new account, signing paperwork for that to happen.
Can you put a property you own in another country into a PA trust?
Depends on the country. So we've done all kinds of different countries. Most times, though, I'm going to tell you that they would be controlled by the country that we're dealing with. So I'll just use Canada for an example. So Canada has different laws. Like when you pass away, there's a tax due that we don't have in the US because we get what's called a step up in basis. So in Canada, when somebody dies, if they bought like a cabin, let's say for $100,000, and when they die, that cabin's worth $175,000, they have to pay tax on the $75,000. So the growth of that. So I could put it in a Pennsylvania trust. However, I am not going to be avoiding that Canada law. I'm still going to have to do that. There are some countries where it really makes sense to put it into a Pennsylvania trust so you can get access to it easier. And that has to do with their laws. But we have to look into country by country to figure that out. Over the years, I've done a lot of different countries. To be honest with you, most of that came from physicians that I represented from Geisinger, to be honest. I looked into a lot of different countries over there. So it would depend on the country that we're dealing with. But yes, it is possible.
Okay. And then last question here, and then we'll move on here. If you are married and do not put your home in a trust, or if you are married and do not put your home in trust, can a nursing home take part of your home for the expenses?
Yeah. So what happens there is, let's say husband and wife own the house together. Let's say husband goes into the nursing home. They will not take that house right there and right then from the spouse. That is protected. But at our office, we would want to do something to protect it, because if the spouse at home, so let's say the wife at home, passes away, that deed is going to have the person that's at the nursing home inherit it, and then it's going to be used mostly for the cost of care at $12,000 a month. The other thing that happens all the time is, and this is a change in the law. So there used to be a lot more spousal protections in Pennsylvania. You know, when I was a young attorney, there were spousal protections, and now they've kind of eroded. And this is one of the things that has changed, which is why spouses really have to protect themselves. So let's say again, husband's in the nursing home, wife's at home, and she decides that she needs to sell the home. Too much upkeep. I'll tell you right now, my husband's in a nursing home, I'm selling our house. Too much upkeep. I just my son going off to college, I've already realized like this is too much. But anyways, so if I sell the home, what happens now is the state's going to come in and say some of the proceeds from the sale of that home have to go towards his care. Well, that's really bad for a spouse, because what if I'm going to buy another home that might be smaller? It might be more convenient to take care of, but it might not be less expensive. Or let's say I am not gonna buy another home. I'm gonna go into an assisted living or personal care, and the cost of that is $5,000 or $6,000 a month. I really need that extra money for that extra expense. Or I'm gonna rent someplace. And so what's happened is, if a spouse decides to sell, the state is coming in and allocating some of that money from the sale to the spouse that's at the nursing home, which didn't used to be the law. So, and if you do nothing, both spouses die, the state comes in with what we call recovery. So they'll come in after both spouses die and take whatever was paid for the care. That's why we often put houses in trusts to protect against all of that. So first of all, we think about, well, what is the difference when somebody dies in a will versus a trust? And typically we're going to think about, wills and trusts both can be in Pennsylvania inheritance taxable. So Megan went over the taxes. It's 4.5% to our kids, 15% to our nieces and nephews. Sometimes people think simply having a trust avoids that tax. That is not true. If you have control over that trust, your beneficiaries are still going to pay that tax. So you have to talk to the attorney and make sure it is that type of trust. Also, as Megan talked about, you get a step up in basis. And so there's sometimes that I actually want to pay in Pennsylvania inheritance tax, like for instance, with a house, because if I sell it, I might be paying, if my beneficiaries sell it, they might be paying more capital gains tax. Like in my situation, if I were to pass away and my children sold my home, I would actually prefer that they paid inheritance tax and not the capital gains tax, because my husband and I have lived here a long time and we've made a lot of upgrades. Probate fee versus no fee. So with a will, there is a probate fee. We have to pay the courthouse. Also during COVID and even today, it's irritating sometimes. We don't have access to getting something probated. It's harder to get an appointment. We used to just walk in and now we can't. During COVID, there was 8 weeks in Lycoming County that I couldn't probate a will. In Center County, we didn't go a day without being able to do that. So the probate fee and the probate process, that attaches to a will, but not to a trust, which is a huge issue. Attorney's fees are kind of all over the place. So typically, most people would say we're going to pay less fees with a trust than we are with a will. And that was the way Pennsylvania law was, that basically there was a percentage that attorneys would charge for probate for a will and a lesser percentage for a trust. At our office, that's not necessarily always true, because we work with you, whether you have a will or a trust, to reduce those fees. We try to get you organized up front so that when you pass away, we have to do less. And that's not just for us to do less. That's also so your kids have less to do, particularly if your kids are out of town or they have really busy lives. We don't want to leave a mess for them. So at our office, we don't charge that percentage. What we do is we really look at how much work is there. And sometimes people have paid us money to get things organized during their life. And that kind of comes back to their children because upon their death, there's not as much to do. And so we don't charge as much to do it. So, but I would tell you historically, we would think of attorney's fees being less for a trust. I still think there's some truth to that because there is a little bit less to do. Executor's fees versus a trustee's fees, I think these are kind of similar. I think that, either needs to do some work and can't just charge a percentage, but really needs to do things. Really, part of what takes so long sometimes is figuring out what to do with the house and cleaning out the house after somebody's passed away. Beneficiaries contesting a will is definitely more contestable than a trust. So whenever I have a situation where maybe we're not doing what people think we should, I will use a will. I will use a trust in that situation. Now, in either situation, we would consider putting in an interitorium clause, and that means that if somebody objects to it, they can go ahead. They lose, they're taken out of anything. So if the will says, my daughter gets $100,000 and she says, no, I was supposed to get $2 million, and she objects about that, she loses, she gets nothing. So what it does is it makes people, consider that a little bit more. Trust administration after death. Trust assets do avoid probate, so we avoid having to go to the courthouse about them. We avoid any of those ways. However, there is a process that's similar. So I have to send out notices, I have to do advertisements, I have to do a tax return. So it's not like nothing needs to be done. I think that's important. But at the end of the day, it is a little simpler with trusts. And so it's nicer that your beneficiaries can get the money quicker and easier. So trusts and levels of care, kind of switching topics now here to talk about if I use a trust and try to protect assets from the cost of care, will that limit me in any way? And really what we're talking about is is when we put assets into a trust to protect against the cost of long-term care, we're really getting people eligible for Medicaid, which pays for nursing home care and in-home care, but does not pay for locally here in Pennsylvania or State College or Wyalusing, wherever you're calling, where you're coming in, zooming in from, does not pay for like assisted living or personal care. And so we need to know, this is really helpful because, nursing homes cost $12,000 a month and it helps with that. But if you wanted to move into an assisted living, we would not be getting money from Medicaid for that. We talked quite a bit about this 5-year look back period. A lot of people know it. So there is a look back. If I give away my asset, if I go into the nursing home and I apply for Medicaid, they ask me, have I given any money away in the last 5 years? And if you have, they're going to assess a penalty. So the best thing to do is to give away all your assets before 5 years. If you can't do that, we sometimes still go ahead with the application. Medicaid will deny it, but they'll impose a penalty period that basically is equal to 1 month for every $12,000 that you gave away. So there's an example here to make this kind of easier, I guess. So what happens if you gift $200,000 to a trust? You don't make it through the 5 years. So remember, if you make it through the 5 years, you're fine. That money's in that trust and it's protected. But what if you don't make it through the 5 years? Then they're going to apply a penalty, but it's not a 5-year penalty. It's a penalty based on what you gave away. So in this situation, we gave away $200,000. We divide that by the average cost of nursing home care in the state of Pennsylvania, which is $12,869.59. I actually divide those on my calculator. I come out with 15.5. And what that means is that the state will not help pay for the care for 15.5 months. And sometimes that's okay, because sometimes we have other money to pay through that 15 months. And that $200,000 is saved, and we're able to do that. So let's do a real example. You transferred $200,000 in November of 2018, and you go into a nursing home in November of 2022. So that is not 5 years. That does not expire until November of 2023. So we only have 12 more months of the look back period. Now we just did the scenario where if we applied, we'd have a 15.5 month penalty. So in this situation, we wouldn't apply. We would just go through the next 12 months of that penalty period. We would pay for that. And then whatever is left could be used to, could be saved. So in this instance, what if you don't have that money? So again, a lot of people have put some money in a trust and they have some money outside. So we just use the money outside. Sometimes people give away everything and they don't have the money outside. In that case, we just take a loan against the trust. So we are able to pull that out. Even this is kind of a worst case scenario. Even in this worst case scenario, we still protected $45,000. But usually some people would have some money outside that we would use to help pay for that. So just giving some scenarios with this. Let's say that Harry has a house valued at $200,000 and $400,000 in assets. In 2012, he put his home and $300,000 into a trust. Okay, so long time ago, 2012. He then was admitted in a nursing home in November of 2018. So what should we notice here? We should notice that we're beyond 5 years. So 2012 to 2018 is 6 years. In 2012, he spent $100,000 on his personal expenses. Because he made it 5 years since the transfer of asset, he protected the full $500,000. They're not eligible to pay for care. Now, why would we want to do this? Well, one thing that people don't realize is that many times people can go into a nursing home for a period of time and then get better. So let's say that somebody goes into nursing home for 10 months, but then they get better and they want to come home. If, let's say that happened to Harry, if Harry did this, he'd still have all of his money that he can live off of. If he didn't do this, he would pay about $120,000 to the nursing home, which is then less money that he has to live on the rest of his life. And that's a really important point for people to know, because I think sometimes people think, when I go to a nursing home, it's the rest of my life, and it's not. Other people think, oh, it's okay if I have to go to a nursing home for rehab, Medicare is going to pay for all of it. And it's not going to. It's going to pay for some, but often people need a lot more rehabilitation than what they provide under their skilled services. What happens if you don't set up a trust? So let's go back. And in this situation, John Smith, he has a house valued at $200,000 and he has $400,000 in assets. He doesn't do any planning. So remember, Harry, smart, he did planning. He was able to protect it all. He's able, the whole $600,000 would be vulnerable for his care. And he's only able to pay, keep about $2,400 or $8,000, depending on his gross monthly income. And so now, if this person, if John came to us and he hadn't done any planning, there are things that we can do that are last minute. It involves using an annuity and some complex things. We can do it, but it's not as good of it. John's never going to get the same outcome Harry got. So John's never going to be as protected because he didn't plan ahead moving forward. So when we think about this, we've talked a lot about long-term care, but when should we think about setting up a trust? So anytime we're worried about long-term care, anytime that we get any sort of diagnosis, but also, I think a lot of times people will start thinking about this, when you have an empty nest, your children are grown and out of the house. Just happened to me, and I have time until I decided to get a puppy, which is now taking my time. If you've accumulated assets that are readily available to help pay for care, that can also be a time to set up a trust. If you have a family history of medical conditions that require long-term care, some diagnoses are hereditary. And so you want to think about that. You want to protect your real estate and your assets. Sometimes people have things that they have family value. I work with a lot of families who have cabins or hunting places, or family farms or family businesses. We really want to work harder to protect those things earlier, because it's not just, is this person getting an inheritance? Sometimes it can be your family or beneficiary's livelihood that we're worried about. And so we want to make sure about that. So what are the positives of pre-planning? It allows more flexibility. So I just gave you some examples that, it's a better outcome. It also, from my perspective, it's a much better scenario to go through for your family. So rather than being in a crisis and your children not knowing what to do, not knowing like who to call, or not having a good power of attorney, or having to go get a guardianship at a courthouse, it's, you have more flexibility, but also, we have a plan so people can follow. So it's just, I can't underscore how important it is. We still get calls at our office where, the worst thing happened to somebody. Mom had a stroke. They have no idea where anything is, we don't even know who we're supposed to be talking to. What if the kids start to fight? What if it's a second marriage situation? A lot of times in those situations, children will decide that they should be decision makers above a spouse that maybe has been married to the other person for 40 years. It's happened to me recently. So it allows control and the best protection of your assets. So at our office, what can you expect? We have a team of attorneys. So Megan and I actually work together on the same team. We also have certified Medicaid planners, Tammy and Kristen. We have care navigators. So there are people who are social workers or nurses by trade that really help people in that crisis to plan the best journey, particularly if you're dealing with a diagnosis of dementia or some other chronic diagnosis where you need a little bit of extra guidance on where can you get good care, what are the steps, how do we get prepared for this. We do individualized planning. We want to know what your goals are, what's important to you. Of course, we're a law office, so we have quality documents. I'm probably a little nerdish about my documents. I really like them. But I think really important is that our hope for you is that you would have peace of mind. Our hope is that, for many of you, setting up a trust allows you to have a plan and gives you peace of mind that you're ready for that. So this is just an example of some of what our clients are saying about us. And talks about, she's so glad that she found our office. A friend of a friend had used us and highly recommended our office. Her mom was going into a nursing home and she needed to find a way to pay for it. We listened to her concerns and worked out a viable plan in placing her assets in a trust. And many times that is the answer. The annuity from the trust together with her Social Security totally pays for her mom's care, and she really couldn't have asked for a better solution. So I think that's important for people to know moving forward. So if you're on here, and I know some of you on here are already our clients, and we love that you get on here. And if you have any questions about this, I also suggest that you schedule a long-term care strategy session. There's no charge for review clients. I always grab your file, sit down. You may want me to re-explain or somebody on our staff, or you may be like, did we do that? They said that on that. Did we do that? Always, we want to do that. For those of you who haven't done planning, this is a great way to get started because how this works is we spend 1 hour and we can do it via phone, video, or in person, totally up to what makes you feel most comfortable. And during this meeting, we're going to ensure your estate planning documents are in good order. Sometimes you already have estate planning documents, wills, powers of attorneys, and sometimes they're okay. And we tell you that. Sometimes one of them needs updated because the law changed. For instance, the law changed in 2015 with financial powers of attorney. So sometimes that needs updated, but your healthcare power of attorney doesn't. So we'll talk to you about that. We'll help you develop a plan for your second half of life. That will include, for many of you, it will include a trust. Now, not for all of you, but for many of you, there's a goal. You want to protect assets against the cost of long-term care. You have a child who has some sort of special need. You have a diagnosis you're worried about. And then we'll answer all your questions about your situation. At the end of our time together, you will know what documents you need. You'll know your options as far as long-term care. And really, our hope for us is that you'll have peace of mind moving forward. After the plan, we develop a written plan with recommendations. And I would say to you that that really sets my law firm apart because we do give you a plan in writing. We give you our advice in writing. That's not a plan that is given to anybody. Megan can tell you because she develops these plans and it is individualized to your situation. And then we work with you to implement the plan. We prepare the legal documents and we walk you through the process. So we do not, in that situation, just say, here's your trust. We also help you fund it. So we'll help you deal with all of your different financial resources. So whether that's Vanguard or PSECU or Woodlands Bank, whatever it is, we help you understand how to get it in there moving forward. So our suggestion to you is that you book a free strategy session today. At some of our offices, sometimes these are, we charge a fee for these, but we're not. Anybody who comes on these webinars, we totally get rid of that fee. But what's the catch? So this is important. This is an important catch. We want you to get yourself organized and move forward with this, but we're only willing to do that if you're willing to talk about your individual situation and provide us with information. So once you schedule your strategy session, somebody from my office is going to call you and ask you for information. And that's fantastic. If you say, I don't want to give you any information, or you want to what if me, what if this, what if that, you're probably not somebody that should do this, because we're really not designed for that. We're designed to talk about your specific situation and give you the best advice possible. If you're not willing to tell me about your specific situation, you're really wasting your own time and mine. So the catch is here that we need to be partners in this, and you need to trust to give me the information so I can give you the best plan. At our office, we are not just going to go in and do a trust and not know everything about you, because that may not be the best thing for you, and I need to make sure. And so I think it's really important that we want to work with you individually, but you also need to understand that it's going to take some of your time to get stuff organized. Now, please know we'll help you in any way possible. Goodness knows I'm not the most organized myself at home. Great at work, but kind of falls apart at home. So we are here to help you. We'll have you sign releases and kind of do some of the work yourselves. For those of you on here who own your own businesses, many of you are really good at whatever you do, but not so good at the record keeping and organizing. That's okay. We'll help you. So I'm not talking about, you having to have perfection, but just a desire to share with us what your situation is so that we can do the best job possible for you. So to book your strategy session with us, you have 3 choices. You can go with chatwithsgy.com. You can email info@PA Elder Council. That will actually, I think, go to Kyle, I'm not sure. Or you can call our office at 800-351-8334. Again, that's 800-351-8334. Now, I will tell you, when you get on the chat with SGY, there's not a box for you to have an hour call. There's only 30-minute calls set up there. That's okay. Go ahead and click on that. And my office will deal with that on the background. Usually we don't do a whole hour with this. Usually we've been doing 30 minutes. But in this situation, you will be changed to a 1 hour now, but somebody still will call you. So I just think that's important. So I did say an hour, but just go ahead on that chat with sgy.com. You can even open up a browser right now in your computer, click on that, click with chat with SGY, or you can email or call our office. Our gifts to you, we will give you a $250 off of any planning package that you decide to move forward with. In order to receive that, you just have to let us know that you were on this webinar. Email Kyle and he can send you verification of that. Also, if you'd like our book, Don't Write a Blank Check to a Nursing Home, call 800-351-8334. Get on chatwithsgy.com, and you can get that. So again, that's the information to have that. But just remember, for everybody, after meeting with us, you will have an estate and long-term care plan that is updated with the current law. You'll know your payment options for long-term care and have assets protected should a health crisis occur. And you'll have peace of mind knowing that you and your loved ones will be better prepared for financial or healthcare challenges that will come your way. And you'll have really given a gift to your children or to whoever your decision makers are by planning ahead. So we're here for you. Kyle talked about our podcast and our YouTube channel, and he put those in the link earlier. We really want to be able to help you get educated to the point that you feel comfortable with this. Anybody have any questions?
Julie, there was one question that I saved for you, since I know that you do have a lot of experience with this. If someone is having a farmland easement that requires a deed change, do you have any preference on whether that easement is done before we put it into a trust or after it's in the trust?
So it would depend on the type of easement. So some easements are more county easements, some are done by the state and some are done by the federal government. I don't really have a preference. I've done it both ways. I've done it prior to putting it into the trust, and I've done it after putting it into the trust. And either are able to be done. Prior to putting it in the trust, it's a little easier to deal with whatever agency we're dealing with, because it's a deed that's still just in husband and wife's name. But if it's after, that's no problem. The big important point is sometimes with easements, you'll get money. Sometimes you don't. It depends on, if it's a conservation easement or if you're talking about the county ones that come with money. If the house is already in, or the farm is already in the trust and that easement comes in, it depends on what type of trust we have. Some trust, the money should stay in the trust, and some money would be considered income and could be given out to you. So I think the important question for me would be where do you, if you're doing a type of easement that you get paid for, where do you want that money to go? If you want it protected, then we would want to do it afterwards.
If a donor couple put their home in a trust 5 years ago, but recently decided the home needed construction modifications to be able to live in the home longer, is it okay for the donor to pay for those modifications, or should the trust have paid?
Either one can do that. The donor can pay. If there's money in the trust can pay. Either one. I'm assuming this is a home that you live in. So either one.
Mm-hmm.
Do you have to put all your property in your trust, trying to sell part of property?
No, you don't have to put all your property in the trust. Now, I have to tell you, if it's all on one deed, there's no way to get it into the trust unless you subdivide it into 2 different deeds. But we often have people who have, 3 or 4 different pieces of property, and maybe they are going to sell one. We may not put that into the trust. We may just, let them sell that. Or we may put it in the trust and sell it from there. So.
Could you speak a little bit about what is referred to as the spend down?
Yeah, so the spend down means that when I'm in, let's say I go into the nursing home and I have $200,000. I would need to spend down that $200,000 to $2,800 or $8,000, depending on how much my income is. But let's just go with $8,000, down to $8,000 before the nursing home, before Medicaid would help me pay. At $12,000 a month, every month I'm going to pay the nursing home $12,000. We push that spend down faster. And what we do at our office is we'll take some of that money, about half, it doesn't work out perfectly, but about half. We're going to save that, put it into a trust and protect it, so that we've really only going to spend down $100,000, but that spend down is actually going to go pay for care. Now, understand, we don't just write a check to the nursing home for $100,000. We pay the bill every month. But, if the nursing home bill, the prescription drug bills, all of those things, they end up, very quickly eating into that. So again, if I had $200,000, I was going to protect about $100,000 and spend down about $100,000. And just so you know, that formula is given us by the government. That's not arbitrary. That's not by me. I have to figure out each person's a little different because it depends on what your income is, and it depends on what the actual cost of care is in the facility that you're at. But about half will be protected, and the other would be spent down. But like I said, in this situation, $100,000 divided by $12,000 a month, it's about 8 months. That whole $100,000 is going to be gone. When I started my job, the average cost of nursing home care in the state of Pennsylvania was about $2,000 a month. I remember people being very upset about $1,800 nursing home bills. And I just recently had a client that the bill was $19,000 a month. I couldn't believe it. I thought it was wrong. I wasn't listening to my staff person. I was like, that can't be, but it is. So.
Our home is already in a revocable trust with your firm, and we recently made an addition of a back porch to our home. Do we need to adjust anything as far as the value of our home in our trust?
No, that would be fine. something that you would want to tell me at a review appointment, I might update my asset list, but there's nothing legally that you have to do.